Judge throws out most of artists' AI copyright infringement claims. A federal district court judge has thrown out most of the claims that a group of artists asserted against artificial intelligence platforms that they claim use their work without permission. Sarah Anderson and other artists filed a putative class action on behalf of themselves and other artists to challenge the defendant's creation or use of Stable Diffusion, an AI software product. Plaintiffs allege that Stable Diffusion was trained on plaintiffs' works of art to be able to produce output images in the style of particular artists. The three sets of defendants each filed separate motions to dismiss. DeviantArt also filed a special motion to strike. The judge granted the motions to dismiss and deferred the motion to strike. Consumers use the AI platforms at issue by entering text prompts into the programs to create images in the style of specified artists. The new images are created through a mathematical process that are based entirely on the training images and are derivative of the training images. The defendants sought to dismiss two of the plaintiffs' claims because neither of them had registered their images with the U.S. Copyright Office, as is required before the owner of a work can sue for infringement. They also sought to limit Anderson's copyright claim to the 16 collections of works that she registered. The judge granted these motions. The defendants argued that Anderson can't proceed with her copyright infringement allegations unless she identifies with specificity each of her registered works that she believes were used as training images for Stable Diffusion. The court noted that a search of her name on the IHaveBeenTrained.com supported the plausibility and reasonableness of her belief that her works were, in fact, used in the lay-in datasets and training for Stable Diffusion. The court found that a sufficient basis to allow her copyright claims to proceed. It is unclear, for example, if Stable Diffusion contains only algorithms and instructions that can be applied to the creation of images that include only a few elements of a copyrighted training image, whether DeviantArt or Midjourney can be liable for direct infringement by offering their clients use of the Stable Diffusion library through their own apps and websites. One of the plaintiffs' theories of infringement was that the output images based on the training images are all infringing derivative works. The court noted that to support that claim, the output images would need to be substantially similar to the protected works. However, noted the court, none of the Stable Diffusion output images provided in response to a particular text prompt is likely to be a close match for any specific image in the training data. The plaintiffs argued that there was no need to show substantial similarity when there was direct proof of copying. The judge was skeptical of that argument. This is just one of many AI-related cases making its way through the courts, and this is just a ruling on a motion rather than an appellate court decision. Nevertheless, this line of analysis will likely be cited in other cases now pending. Also, this case shows the importance of artists registering their works with the Copyright Office before seeking to sue for infringement. Need help with your copyright? Book an appointment with us at www.eonlaw.com. Eon Law, unleashing genius.